This is Matthew McDonald. I'm a member of the Judicial Committee for the Knoxville Bar Association, and we're conducting these interviews with judicial candidates this year to better familiarize the bar and the general public with the candidates. And I'm here this afternoon with Chancellor Clarence E. Pridemore Jr., who is the Chancellor for Part 2 of the Knox County Chancery Court and was first elected in 2014 and is seeking re-election to the same seat this term. Good afternoon, Chancellor.
Good afternoon.
And we have a few prepared questions that we'll be asking of all the candidates. These have been approved by the Knoxville Bar Association and the Judicial Committee, and we'll just go through them if you're ready.
That's fine, whenever you're ready.
Okay. Chancellor, first question is, what makes you qualified to serve?
Well, to answer that question, I would say, first of all, my experience in the last 7.5 years I've been here, we've presided over nearly 10,000 cases involving all matters from probate to domestic relations to conservatorships and administrative appeals. And then prior to that, I was in private practice, which gave me experience from the other side of the bar, or the other side of the bench, where I realized what it's like to try to run a private practice and be in multiple courts on multiple occasions. And I've also made it a point of mine since I was elected to try to treat pro se litigants the same as any other litigant who has an attorney. I've made it a point of our office to try to work and coordinate things with people who are unable to afford or have an attorney. And I think that gives me the qualifications also to deal with both the pro se people and the litigants and attorneys in the courtroom, both. And as far as my weaknesses, I would say probably the one thing I think all judges have is sometimes when you're in court, you have to leave out your own personal opinions because you have to apply the law as it's written, not what you may think is right or wrong, but what is written is what you have to do. Sometimes you don't want to, but you have to.
Thank you. In your opinion, what have been the most effective methods for improving court procedures and efficiency?
I almost hate to say this, but the most effective measures for improving court came about because of COVID, where we ended up allowing to have filings by fax or email. Instead of being in person all the time for your filings, we've allowed individuals to do multiple Zoom videos, Zoom motions and Zoom trials both, and even have the introduction of exhibits by Zoom. And I think the technology has greatly improved the court process. And I wish we could keep it more of that with the electronic filings, potentially someday get into an electronic filing system where you could do actual paper filings or electronic or both, like the federal court system does all electronics. I think it helps not just the attorneys, but the pro se litigants and attorneys from out of town. It also prevents a lot of travel. It helps with scheduling people in multiple counties, and especially with attorneys that go to multiple courts. So I think COVID's brought about a lot of change in the technology, and I think we should do more of that myself. I hope we keep more of that. Not just because of COVID, I just think it helps the whole court system move along faster.
Thank you. What additional improvements would you recommend for the future of the judicial system?
Well, besides my recommendation, what I just spoke about, which was the issue of the Zoom and the electronic filings, I think it would also help with this has came up in some discussions from the AOC before. There's been talk of some type of an indigent fund for litigants involving things like evictions, or someone that's being evicted or having to have a child custody situation, not where you're trying to terminate someone's rights, but something where they still may need an attorney. There's been talk at the legislature about funding something like that, but it's never came about. And I think it would help the system a lot if you had these pro se litigants involved in these situations that would have some legal representation that could help them through the court system and move things along better. I think that would greatly improve the flow of the court system.
And you've already spoken a little bit to this, but in terms of challenges with technology and some of the funding for pro se litigants, but if you could just recap, or maybe something different, what is the biggest challenge you see facing the court today?
Probably the biggest challenge right now faced the court in the future would be another pandemic or a more serious pandemic. We didn't shut the courts down, but they ground to a very slow pace during the COVID pandemic because the court system and the technology, especially in Chancery Court, was not up there and up to speed to deal with it. And hopefully we can learn from the previous pandemic and the ongoing pandemic and implement these procedures so they'll be in place for the next time, and we'll have a plan ready if we do have another pandemic of some kind or something more serious. Also, there's been the financial issues. In the very beginning, we had to have a furlough for a number of employees from the clerk's office. I don't think the funding was there also to deal with a decrease in the filings and the revenue coming in. So we should probably plan for that in the future at some point if it happens again and make preparations for that.
And this is a bit of a non sequitur here. Who are your judicial role models and why?
I would probably say Chancellor John Weaver, my fellow chancellor in part one. He's helped me numerous times when I have issues come up that's kind of unique I've never dealt with, or I just want to bounce something off of him. And I think he's probably the smartest judge here in Chancery Court or the courthouse. I like him a whole lot. He's a very nice guy and very smart.
And so the KBA has also let us know that we're allotting 1 minute for just a closing remark, and you may begin whenever you're ready.
That's fine. I would just say, like I said in the beginning, I've been here 7.5 years. You can probably ask any of the attorneys in town or any pro se litigants who have been in front of me. I try to treat everyone the same. I try not to bring any personal feelings into the courtroom. I treat everyone with respect, and I think if I can continue to do that, because not only do I have the experience from being on the bench, but I have the experience from being in private practice on the other side of the bench before I became elected in 2014.
Okay. Thank you very much, Chancellor Clarence E. Pridemore Jr.
Thank you.